Welcome to the Bar Exam Toolbox podcast. Today we have another episode as part of our Listen and Learn series. This one covers the Commerce Clause. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we're talking about a very testable area of constitutional law, the Commerce Clause. The reason the Commerce Clause is so testable is because it's got quite a few prongs and then has tests within those prongs. So that gives examiners quite a bit to work with when they're coming up with questions. Those tests within prongs are also the reason that the Commerce Clause can overwhelm students. First, you have to identify whether it applies. Then you have to identify which part of it applies. And then you've got to apply it. So here are the steps you want to take when identifying whether the Commerce Clause applies. First, you have to look at who passed the law. If it's Congress, then we're talking straight Commerce Clause. If it's a state, then you're in dormant Commerce Clause territory, which we won't get into today. Next, we have our rule. Congress has the power to regulate interstate commerce under the Commerce Clause of the Constitution. The modern formulation of the commerce power, which was developed in the United States versus Lopez, tells us that Congress may regulate A, channels of commerce, B, instrumentalities of commerce, and C, activities that have a substantial effect on commerce. Prong C is where we find the most nuance, which means, for the purpose of exams, the most testability. Here's another quick thing to note. The Lopez formulation is an or situation, meaning you don't need to find that a law governs channels and instrumentalities and has a substantial effect on commerce in order to be constitutional. It only takes one category to make the Commerce Clause work. So adding to our rule, we are now complicating our substantial effects test with some additional requirements. First, the activities contemplated by subsection C must be directly economic in nature. Lopez added that in order to classify an activity as economic, one could not pile inference upon inference, meaning Congress cannot rely exclusively on the indirect economic consequences of an activity. In Morrison, we saw the Rehnquist court interpret this to mean that violence against women was not directly economic in nature, and that the aggregate effect on commerce was too attenuated from economic activity to uphold the relevant section of the Violence Against Women Act. Now, what if an activity is economic, but limited to intrastate activity? Congress may still regulate that activity if there is a rational basis to conclude that the cumulative or aggregated impact of the activity has a substantial effect on interstate commerce. Additionally, while economic activity includes distribution and consumption of commodities, it does not necessarily need to include commercial sale. Rake gave us that rule as well. And finally, Congress is limited to regulating actual activity, not inactivity, and may not, therefore, compel activity. So let's come up with an analytical stepladder before we dive into the fact pattern. First, who passed the law, Congress or a state? If it was Congress, then does it fall within their Commerce Clause power, meaning does it regulate A, channels of interstate commerce, B, instrumentalities of interstate commerce, or C, activities that have a substantial effect on interstate commerce? Okay, so let's say we're in category C, activities that have a substantial effect on interstate commerce. Is the activity directly economic in nature? So for example, does it relate to the distribution and consumption of commodities, or does it have indirect effects on interstate commerce? Where is the activity taking place? If it is only happening in one state, is there a rational basis to conclude that the cumulative or aggregated impact of the activity has a substantial effect on interstate commerce? And finally, are we sure that Congress is regulating activity, or is it trying to compel activity in the face of inactivity? So let's now go to a fact pattern. This is pulled from question 4 from July 2009 of the California Bar Exam, and it has been edited for brevity and focus. In a recent statute, Congress authorized the United States Secretary of Transportation to do everything necessary and appropriate to ensure safe streets and highways. Subsequently, the Secretary issued the following regulations. Regulation A, which requires all instructors of persons seeking commercial driving licenses to be certified by federal examiners. The regulation details the criteria for certification, which requires a minimum number of years of experience as a commercial driver and a minimum score on a test of basic communication skills. The State Driving Academy, which is a state agency that offers driving instruction to persons seeking commercial driving licenses, is considering challenging the validity of Regulation A under the United States Constitution. So who has passed the law? Congress. And why? To do everything necessary and appropriate to ensure safe streets and highways. So what are they regulating? Regulation A is regulating commercial driving instruction. So that falls under prong C, an activity. So is this an economic activity? This is a commercial driving instruction, which means it has to do with ensuring safe transportation of commercial goods, and it could also be presumed that this licensing process is happening for a fee. So this could be considered economic activity. But where is this activity taking place? State Driving Academy will argue that this activity is entirely intrastate and therefore outside the scope of Congress's power. But what did we learn earlier about intrastate activity? That even intrastate activity may be regulated by Congress so long as there is a rational basis for the belief that such economic activity would, in the aggregate, have a substantial effect on interstate commerce. So here it could be argued how well truckers drive has a substantial impact on interstate commerce because even though the licensing is happening within the state, it impacts whether commercial goods get from one state to another depending on the ability of the truckers to get the goods there safely. Remember, a lot of the facts you come across in your exams will be intentionally ambiguous in order to get you arguing. What's often less important than the conclusion is how engaged and thoughtful your reasoning was on your way to the conclusion. So feel free to go ahead and play with these facts as you consider the Commerce Clause. And with that, we are out of time. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.